Good evening, this is Rahul Reddy. We are here live from Houston, Texas. REDDY NEUMANN PC does bring in immigration updates every week at Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily. Emily, what do you have today?
Thanks for joining us. We wanted to talk about an issue we've been seeing in a lot of the consultations we've had over the past week or two, where there appears to be increased scrutiny of F-1 status for individuals who are later applying for H-1B visas or H-4 visas at U.S. consulates abroad. We also had a court decision that came out recently that deals with the CBP's procedure of looking into cell phones and laptops and emails when you're at the port of entry coming into the United States. We also have updates regarding who's in charge at USCIS and who's in charge at DHS. It seems like it's a merry-go-round these days. You can never tell who's in charge, but we've got updates for that. We also wanted to talk about something that's a question that we get quite a bit is what happens when you are outside the U.S. and working remotely for a U.S. company? Do you need to have some sort of immigration status or work authorization to do that? And lastly, we wanted to talk a little bit about the upcoming lottery for next year's H-1B cap. I know April still seems like it's a ways away, but with this new lottery system, we're expecting some kind of announcement soon about this new registration.
Emily, we have seen unprecedented instances with regards to the people who have some doubtful maintenance of the status on the student visa. Can you explain some of the things? What are the things that you feel that the students should do to maintain their status in the United States? And then we'll go on to each different steps where the problems are occurring.
Yeah, so definitely, there are certain things that you have to do to maintain your F-1 status while you're here, and that is attend the classes, make sure you're taking a full course load and don't drop below that full course load without prior approval from your school. You can't work without authorization, and you can't take too many online courses. There's a limit on that. Those are the main things that you need to be doing to maintain your status. We also see issues with people with this day one CPT that we talk about all the time, where they've already graduated, moved on to a different university that provides CPT at the same degree level without requiring the person to go up a degree level or without requiring them to attend classes for 2 semesters before they qualify. Those seem to be problematic according to USCIS when you later attempt to file a change of status from that situation. And all of these are coming up at the consulate. We've seen recently people who are filling out their DS-160 and they're not mentioning all of their schools that they attended, and that's causing problems when they're applying for their H-1B. So can you give us a little bit more information about that?
Yeah, for these people, especially who are attending these particular 2 universities, I want to name the university assembly, which is Cumberland and Campbellsville. We're particularly concerned about these 2 universities. They are granting day 1 CPTs on the day that they join the university, and when these people who have attended these 2 universities are going to visa status, and when they are attending for either H-1B or H-4, we notice that they completely ignore, they don't even put the university name at all that they attended. I spoke with the people, why did not you put the university name in there? Because in the DS-160, you have to mention the past employers, you have to mention the past universities that you went to, and they're not mentioning. When I asked, why did not you put, I didn't graduate from that university. But that's not an excuse though. We are also concerned that these 2 universities and some other universities also giving work authorizations on the day 1 that you join the university doesn't require people to attend the classes at all. And these universities are also not looking into if these students are actually working properly on the CPT that's actually is required according to their own standards. So I'm a bit worried that for these people, and they're getting rejections when they're applying for the change of status. We have noticed that USCIS is rejecting the change of status from F-1 to H-1B if these students are joining these universities that are giving day 1 CPTs. We have also seen that when they go to stamping, they're having difficulty facing while you are with regards to whether or not they maintain the status. Previously, Emily, I didn't saw that many rejections in the consulate when these people have attended the universities that give day one CPTs and go out. But recently, I've noticed that they are questioning whether or not you attended the classes. In some of the people that I have had consultations recently, they have issued a bar on them that they misrepresented themselves when they went to the consulate. If they have not listed the university, they said they misrepresented. If they listed the university also, they said they misrepresented. If they did not list, they said they misrepresented because you are supposed to list the university you didn't list, so they put a bar on them. And if they list the universities that they give the day one CPTs, what they said was that, look, you did not went there to attend the school. You are telling, they asked the question, did you attend the school? What's the purpose of you joining the university? And if they say the purpose was for going to college, they asked, how many days have you gone to the college? After a careful examination, they found that the reason why this student joined the university is to get a work permit, not to actually go to the college. And they have rejected and they put a par on these people. So I am very worried for the students who are attending these day one CPT universities. We're very worried about them. So many cases getting rejected for those things. Please be careful if you're intending to join. If you're already joining, already in those schools, please contact a lawyer immediately. Emily, I get a lot of these calls, people telling, I don't have any option. My H-1B lottery is not selected, my H-1B is rejected, I need a work permit, and that's how they go to these universities. Is it a proper cause to get the...
Yeah, I think it's, potentially a short-term gain, because obviously you can work and that solves your short-term problem of needing work authorization, but the long-term impact, your ability to come back in the future, your ability to change status, the potential for an inadmissibility ground that's a permanent bar to you coming back, is just, the risk is way too big for that potential short-term period where you get that work authorization.
And then we still have the August 9th memo of 2018, which is a temporary injunction by the court, but we don't know when the temporary injunction is going to be lost, and that may be a big impact for the people who are doing the day one CPT. Emily, you said now the court has limited these Customs and Border Protection ability to search the electronic devices. Does this mean that now all the clients can, their WhatsApp and their emails and their laptops and texts will not be searched anymore?
No, unfortunately. So in this particular case, it was brought by several U.S. citizens and a lawful permanent resident who, when they were returning from international travel, had their cell phones looked at, had to give their passwords to open up their laptop and those sorts of things. And so these individuals brought a lawsuit against CBP saying that it was an unlawful search. And the court agreed with them and said CBP does not have unrestricted access to look at anybody's electronic devices just because you're coming into the country. That being said, they still have the ability to search electronic devices when people are coming into the country. They just, one, have to have a reasonable suspicion before they can do it. And two, again, this case was brought by citizens and permanent residents, so it's unclear whether it really applies
to the non-immigrant visa people. Yeah.
So there is still a very high chance that when you're entering the country, you may be subject to search of your electronic devices. So please keep that in mind.
And what we have noticed sometimes is that when people communicate any wrong things with regards to the immigration, we have noticed that they open the WhatsApp and then they find out information that's contradicting the purpose for which they are visiting. We have had many situations where people were being sent out of when they were trying to enter into the country. So please be careful. Nowadays, there is absolutely no privacy at all. So if you're communicating with WhatsApp, text, emails, there's no privacy. Even on the phone when you speak, I don't think there's any privacy left anymore. Look into what Snowden has said, that they're recording everything, so be careful on those things. Emily, on the leadership change in the USCIS and DHS, what's going on, who is moved into who.
I
Did you have to
actually
look
have notes
into,
for this one.
there's only 2 positions, Emily, and then you have to look into the paper.
I do, because I mean, we're on what, our 5th DHS secretary now? They're all
In this
acting in this administration. I mean,
yes.
this is just unprecedented. They're all acting. No one's actually been appointed and gone through Senate confirmation. Apparently, that's kind of how Trump likes to do things for his cabinet positions. So there's more flexibility. But yeah, so now we have the current leader of, or I guess the previous leader of USCIS is now becoming the deputy over at Department of Homeland Security. Okay. So now we have the deputy at USCIS moving up. We have someone who was at the Office of Policy and Strategy that's moving over to become the new acting deputy, and then the person who's replacing her is a former, worked with FAIR, the group that really wants to limit legal immigration. So, all I can say is with all of these changes, I think that there's going to be, again, more chaos, which tends to be the way things are in immigration right now.
Let me pause you for a while, Emily. So, if I'm an immigrant, I don't care what you spoke, which one moved where. Now, why don't you tell me your honest opinion, with all the changes what occur right now, are we going to get a better administration, get a person who is going to look into the laws and apply the laws properly, or do we still continue to get the improper denials like we are?
Yeah, I think it's not going to get better. I think it's probably going to continue to get worse. I mean, clearly he's choosing people that are for restrictive immigration, and the whole purpose is bringing them on is for them because they're looking for ways to further restrict legal immigration.
So, Emily, the laws have not changed significantly. Actually, the only law that I believe that has changed in the regulations is the way the lottery system is conducted, which actually they went in a very proper way of doing that. And I agree with most of the things what they're doing in the lottery system. But is there any other things, laws and regulations that changed when this administration came in? So how can it be that the law is interpreted differently in the before administration, and then it's interpreted very restrictively, and you're telling that it's going to be more restrictive with these new people coming in?
Mm-hmm. Yeah, I mean, I think that is clearly arbitrary when you file a case 3 years ago and received an approval, and you file an extension of it 3 years later, and now all of a sudden you're getting a denial for the exact same circumstances, same job. And the denials are, all of a sudden the beneficiary is not qualified for the job, or all of a sudden this job is not a specialty occupation, when nothing has changed regarding those job duties. They're not even arguing that the previous petition was denied in error. They don't have to do that anymore under the memo regarding prior adjudications and deference. So it's, they're just doing it. Yeah. I don't think that's legal to do that.
Emily, on the 2021 H-1B registration requirements, now this is where the people will file in the lottery in the March and April of 2020 for the quota which starts on October 1st. Obviously, everybody knows that they need to have an employer, and there must be a professional position which requires a specific degree as a minimum requirement. Now, on top of that, walk me through. If I were in a student visa, or if I were on the H-4 visa, or if I'm in India and I want to come here on H-1B, what should the employee or employer do to get in the lottery system?
So as of now, the plan is that there's going to be an electronic filing. We don't know when yet. What we do know is that the government will announce the dates for that system at least 30 days in advance, and that filing window for the registration should be open for at least 14 days before you start filing actual petitions. So that would suggest that maybe the last 2 weeks of March might be the actual registration window, which means maybe in mid-February we should get an announcement of when that filing window will open. We're already close to December, so hopefully sometime in the very near future we'll get an update on that. But that is kind of how it's going to work, or at least the timing. Now, if you are having your employer submit your registration in this lottery, they're going to need to have your basic information, just your name, your passport number, date of birth, whether you have the U.S. master's degree to qualify under the master's cap. It's all just very basic information, and it's the employer that is going to submit this on your behalf. And the employer is going to have to be updating their name, their tax ID number, the mailing address, and then give the company authorized signatory or representative's information. When the employer is filing or submitting that registration, they do have to confirm that they have a valid job opportunity and that they intend to file a petition on behalf of this person if they're selected. They also have to pay a $10 fee for each person that they're registering for. So that is how they're planning on minimizing these duplicate filings that we see happening a lot, that it cause a lot of problems for people later. We definitely don't recommend filing with multiple employers unless you truly have a genuine multiple job offers, but that's usually doesn't apply to any situation we've come across when we've been contacted to consult on these kind of issues. So that's what we're looking at. Once the registration has been done, they should be notifying people when to file their actual petitions, and there'll be a 90-day window. I would assume that's going to be April, May, June. So that's kind of the plan for next year as of now.
Emily, can I file through 10 different employers in the lottery system since it's only $10?
No, it is a huge risk to do that. USCIS is monitoring this system, and they will be, they're looking for fraud, they're looking for criminal activity, they will be referring people for investigations, criminal investigations in those kind of situations.
So even if somebody is doing it, it's the employer who is doing it, it's not me, the prospective employee who is doing. Why should I be worried about it?
Well, when you submit those 10 registrations, if you get selected multiple times, which employer do you plan on filing with? And they're tracking all of this information. You've already given the government your passport, name, and date of birth. They can very easily figure out that your name has been submitted multiple times. They're going to be looking at these different employers, and they very well could come back later on. I mean, we're seeing people who did this exact same thing, not with this electronic system, but before 3, 4, 5 years ago, filed with multiple employers, got multiple approvals, thought everything was great. They go to file an extension with a completely different employer 3 years later, and all of a sudden they're getting a notice of intent to revoke or a notice
after
of
4 or
intent
5
to
years
deny.
that they got the H-1B approval.
Same thing happening at the consulate. When you go for your visa stamp with a completely different employer, you think everything's fine, it worked out for you. 6 years later, you apply for that visa stamp, and they're going to be questioning, what was that first project that you were sponsored for? Did you actually work on that project? Because all the time,
How
it's
many
an
times have you
in-house
seen
project.
those intent to revoke, or how many times have you seen those things questioned, Emily?
I mean, it's like every week we see one case of that. It's quite common.
Yeah.
So definitely do not file with multiple employers. I understand the, I guess, the desire or the want to get selected in the lottery. That is an important point in your career, but it's not worth it when you think about the long-term impact to your potential green card and to your ability to stay in the country in the future.
Let's go to the Q&A. Question comes from Romy with regards to the change of status from J1 to H1B. If the J1 to H1B has gone through properly, will there be any problem that might occur at a later time? Romy, there is two things that you need to be careful when you're moving from J1 to H1B. Either you are not subject to the 2 years home residency requirement, or you got a waiver for the 2 years home residency requirement. If either of those things have occurred, you would be changing the status from J1 to H1B. However, though, when a person moves from J1 to any other visa, that part, that how you're eligible to move from J1 to H1B may be questioned at any point of time in further, even if you move from H1B to, for example, to H4, or any other visa, they may question it. Hey, how did you move from J1? So I would always keep the documentation, whether saying that that J1 that you had does not require 2 years home residency requirement. Or if you got the waiver from the USCIS, I would include that waiver at every stage of what I do with immigration, because I have seen RFEs coming at many different stages for the same thing which you resolved it previously. So I'd be careful, just the same documentation, not many questions. 2 years home residency not required. Provide the evidence, and then you copy the same thing and give it to all the lawyers whom you come across.
Shakti from YouTube wants to know, the visa is stamped currently and it's valid until March of 2020, but traveling to London this December for the Christmas holidays, and already has the petition approval with the I-94 that's valid until 2022. So we have a visa stamp that's expiring in March. We have a petition that's not expiring until March 2022, and wants to know, when entering back using this visa and the petition, how long of a duration will you get on the new I-94? So when you're entering in, assuming that your passport is valid beyond 2022 and your petition expires, your I-94 should be granted to match your petition extension that's valid until 2022. Now, we do see from time to time mistakes happen on that, and they give you the validity of the visa stamp instead of the extended petition. So before you walk away, please check that date that they stamp in your passport and make sure they've given you to the date that matches your petition validity. And if they haven't, have them correct it right then and there, because it's much easier to have it corrected then than to try to do it later on through deferred inspection.
Chandrasekhar has this issue, a dilemma with regards to the EB2 or EB3. He already got his I-140 approved and he wants to port. That's a very tough question for Chandrasekhar right now. It could go either way. We have noticed this in the Chinese nationals, that EB3 goes forward, EB2 goes forward, 1 month this way, 1 month that way. So on the recorded line right now, I don't want to commit either way. For EB3 or EB2, which one is better, especially if you're from Indian national, I can't, it may go either way. So, because of the way that I see the Chinese nationals, how it occurred, it is occurring the same way. Sometimes EB3 is going forward. Going forward also, 2 or 3 or 5, 10 years down the line, I'm expecting that there might be one time EB3, one time EB2. It's very hard to judge.
Pete from YouTube has a question. He is currently an Indian citizen and soon to get his Canadian citizenship. Has a valid H-1B visa stamp in his Indian passport, and he wants to know if he's going to need a new visa stamp once he gets his Canadian passport. Well, the great benefit of having Canadian citizenship is that Canadian citizens are usually what's called visa exempt, meaning that you don't need a visa stamp in your passport in order to travel to the U.S. You would carry your H-1B approval notice, and they would give you, grant you entry at the port of entry without the need of a visa stamp.
This question comes from Lee from YouTube, Emily. I want your discussion on this. Hey, a lot of H-1B renewals are getting denied. Does it mean the priority date moves forward?
Well, that's a good question. I don't think so, because the visa, to me, the priority dates move forward based on upcoming supply and demand, not really past supply and demand. Because, yeah, I don't know your thoughts on that.
Most of the people who are getting denied are going to their home country and getting their H-1B and coming back, particularly those people who have been backlogged from 2010 and 2011. I mean, they're not going to just give up and then, hey, I got my extension denied, I'm going back, tata, bye-bye. That doesn't happen, though, at least not when we speak with our clients. The way it happens is that they will try again. They will have to go to India. They'll try to get the H-1B. They come back. They will retain the priority date. So not many people, especially if the priority date is, if they've been in this country for more than like 10 years, they're not going to just leave and go. They're going to come back and fight or get their H-1B approved, file the litigation in some cases, or go to India and come back. So I'm not expecting that the cancellations by itself or the renewal denials itself is going to have a major impact on the priority dates.
Kartik from Facebook has an initial H-1B that was approved for 3 years, valid till 2022, has the visa stamp with that end date, but then transferred to another employer, and on this petition approval got a shortened duration that's only valid until 2020. So if he's planning to travel again, he wants to know if he needs to get a new visa stamp. The answer is no. The existing visa stamp remains valid as long as you're entering in that same category, the H-1B. It doesn't matter that the old employer's information is on that visa stamp. It doesn't matter that the end date of the visa stamp is beyond your current petition approval. As long as you're traveling and re-entering before your current petition expires, you can use the existing visa stamp, but you'll only get entry till the date your current I-94 expires in 2020. You won't get the extra time.
Sriram Srinivas has this question. He's a tenured faculty track position member at the university, and the university is not willing to file for the GC. Can he file by himself AB1B, which is outstanding researcher? The answer to that question is fairly no. EB1A, which is extraordinary ability, can be filed by an individual. EB1B can only be filed by the organization, not by yourself. Romy has this question: what issues might be expected when you transfer from J1 to H1B? Other than the H1B issues that are there, specialty occupation, employee-employee relationship, and certain other, J1 people have to prove that either the J1 does not require 2 years home residency requirement, or you already got the waiver for the 2 years home residency requirement.
Smriti from YouTube wants to know if her and her husband go for visa stamping. He's got the approved H-1B extension already, but her H-4 and EAD extension are still pending. So she wants to know if they decide to go for stamping, will the processing of the EAD be affected? The answer is no, assuming that your H-4 that's pending is an extension of stay, not a change of status. By exiting and getting the visa stamp and coming back in, the EAD processing should not be affected at all. The I-539 can continue to be processed, and then your I-765 will be approved once that is approved.
Question that comes out on with regards to the I-140 approval. This comes out very frequently, that my employer is not giving the I-140 approval. What are the solutions for it? The best way for that is for you to file a Freedom of Information, FOIA, at USCIS. It's so easy to file, and it's online. There is no filing fees attached to that thing. A lot of people do by themselves. So you could file online, and then you could get it. Normally it takes between 30 to 60 days. If any of your employers are not giving, I would suggest don't wait as soon as you get logged off from this YouTube or Facebook. Please go file it. It's so easy to file it, and you will get it within 30 to 60 days, the I-140 information.
Pat from YouTube has an approved I-140 and is getting ready to file the 485. Current visa expires this February, but now has a new job offer and wants to know if it's safe to change employers at this point. So depends on a couple of things. Let's assume that you are maintaining H-1B status and that you have time left on your 6-year limit. Then it is relatively safe to change employers by doing an H-1B transfer, and then your new employer has to file a new labor certification and new I-140 for you that should be done before you reach the 6-year limit. Now, if your I-140, your current I-140 has been approved for at least 180 days before you are changing employers, then you can keep the priority date of the existing I-140 when you file with the new employer. The other option for you would be to file the 485, continue with your current employer, and work for them for at least 180 days until you qualify for AC-21. and then you could potentially move to the new employer without having to redo the green card process. You take your approved labor and I-140 with you to the new employer. The new employer does have to submit a 485 Supplement J, confirming that the job offer is similar to the job that you were originally sponsored for, and that would be another way to switch employers without delaying the green card process.
MJ has a very interesting question from YouTube. His 6 months H-1B has expired, his renewal is denied. That means the extension of his H-1B has been denied. He is going back to India to come back to USA. Does he need to go through the H-1B lottery system? Based on your comment, I'm assuming your I-140 has already been approved, and it's been approved for more than 6 months as of today. If that's the case, which most probably, otherwise you most probably could not have been eligible for beyond 6 years of H-1B anyway. So in that case though, you don't have to go to the new lottery system ever in your life. You can go to India or any other country, you can come back on H-1B, and it's not just the I-140 petitioning company that can file for your H-1B, or it's not just the company that got the extension denied that can file for the H-1B company, that got the H-1B. Any company can file a H-1B, and you are not subject to lottery, not right now, not next year, not next 30 years, not next 50 years, unless there is a change in the legislation.
Jay from YouTube wants to know if it's safe to travel right now for H-1B stamping for the first time. He's heard a lot of administrative processing is happening and wants to know if it's a good idea. So definitely there is a lot of administrative processing happening. Whether it's safe to travel to get the H-1B visa stamped right now really depends on a lot of factors. Number one would be the type of company that you work for and the type of position that you're in. If you are working for a consulting firm and third-party placement, the chances of administrative processing are much higher compared to working in-house at a household name company that everyone is familiar with. You might have an easier process of stamping if you work for that type of company. Other things that could raise an issue for administrative processing is what we talked about earlier with F-1 status. If you had prior F-1 status with any type of unauthorized work or any type of status issue during your F-1 or used one of those day one CPTs in the past, I think you're at a higher risk for administrative processing. And then there's a special kind of administrative processing that requires a security advisory opinion if your education background is in a sensitive technology area. So something that could be used to create a biological warhead or something like that, for example. If you've got knowledge in that area, you may be subject to administrative processing for that reason, and that's not something that you can avoid. So for some people, it is safe to go for H-1 stamping. For a lot of people, it's not. Really just depends on the circumstances.
Emily, the question comes out with regards to the I-140 priority date is August 2018. When would it be current? Can you update anything on the Senate 386 bill, Emily?
I have not seen any updates on that bill other than the fact that we have the competing bill, and everything's kind of split right now. A lot of people are opposing the S-386. A lot of people want to see the other bill passed because it's more comprehensive. At the same time, this other bill is so comprehensive that it might never be signed into law. So people would prefer that at least we move forward with S-386 because it's a small fix that can move forward easily. There's a lot of support for it in the Senate and the House, but it's just not being brought before the Senate floor. The Senate floor apparently is where bills go to die, according to some of the things I read on Twitter today. They're just not moving forward on anything right now.
One question that came out is that the H-1B has been approved, and now they have issued a notice of intent to revoke, and the person's STEM extension is expiring in February of 2020. This is a problem. It has to be, the notice of intent to revoke has to be taken very seriously. The problem here is that if they revoke it, they are not keeping you back in the F visa, Emily, when they should have been. Because if it's been wrongly approved and the H-1B is been now revoked, don't they have to go back to F-1 visa?
Unfortunately, no. Because you're not maintaining two statuses at once. You don't go back to your old status. You're just out of status in that situation.
So if the H-1B has been revoked, though, for you to go back into F-1, into STEM extension that you have, we have not seen any cases where that the university people were able to fix the thing. So you have to take this notice of intent to revoke very seriously. If it's under fraudulent grounds, for example, if it's an in-house project, of course we know what that is. Definitely there's no hope for it at all, not fight. But if it's like some documentation, the end client or vendor letter or something is missing, they have issued an RFE, you need to take that very seriously and respond to that very thoroughly to make sure, I mean, if they are issuing a notice of intent to revoke, they should allege some fraud or wrongdoing from your side or something spectacular that they have seen. Not just, for example, it's an in-house project and they found that it's not, and there is no project, that's fine. But it's just the end client letter or vendor letter or in between, they should not be issuing a notice of intent to revoke. Yes, they are issuing it, but they should not be legally doing it. It should be thoroughly argued and made sure that it's not been revoked.
Dang from YouTube wants to know, if you're applying for citizenship now, do they require the social media history in that application? So at this moment, that is something that is planned. They're in the process of updating the N400 form, the I-485 form, and the I-129, I-539 forms to add social media history to them. But that has not actually happened yet, so that is coming in the future.
A lot of people have this question with regards to the H-4EAD litigation that we do, how much time it normally takes. I would like you guys to refer to the website that we have at rnlawgroup.com. We have given clear picture with regards to how much time it's taking. It takes anywhere between 10 to 60 days. Are there any cases that have taken longer than 60 days, 60 calendar days, not working days? Are there any cases that have taken longer than 60 days? Recently, we did notice that some petitions, approximately around 15% of them in the September litigation have taken a little bit longer. They may be expected to take. And August 30th litigation also, we have about 3 or 4 cases that took longer than 60 days. They're getting resolved. We're working with the USCIS officials and the attorneys there from the other side of it. But are they taking longer than 60 days? Are there any cases that have taken longer than 60 days? Yes, we noticed some of them. Very rarely, but we noticed some of them that are taking longer than 60 days. Previously, we did announce that everything is taking less than 60 days, but I have to correct right now. There are some cases, very rare cases, are taking a little bit longer time than 60 days. And 60 days is the calendar days, not the working days.
AJ from YouTube wants to know, if he applies for an H-1 transfer while he's in the 60-day grace period after a layoff, can he also file for another transfer later after the 60 days is over, even if the first transfer is not yet approved? So I think it depends on 2 things. Number one, did you actually join the company that you transferred to during the 60-day grace period? And 2, has your I-94 expired? So if you joined the first company that you transferred to, and you're maintaining your status with that company based on the receipt notice, and your I-94 has not expired, you should be eligible to then transfer to another company at that point.
Sudha has this question with regards to the 2 universities, one of those 2 universities. Will it be a problem if they have not taken the CPT when they want to move to H1 or H4? Yeah, it could be a problem. I mean, there are I will tell you a couple of other universities that have issued a day 1 CPTs that got into trouble. One is a Silicon Valley University. They have been indicted. Tri-Valley Universities, the management went into jail. These are the 2 universities that got into trouble. And then there are 2 more universities that were actually a sting operation. One is the University of Northern New Jersey and Farmington University, University of Farmington or Farmington University. These 2 universities were been actually a sting operation by the USCIS. There was no classrooms, nothing at all, and these are the sting operations. So all these 4 universities are in trouble. Now, other than these 4 universities, there are about 4 universities that are issuing Day 1 CPT. We are worried how they are issuing Day 1 CPTs. They don't conduct any classes, and recently there is a guy who's been deported when he's trying to enter into the country. They asked the person, he's been a student of that university for 4 months. They asked the city in which his university is. He couldn't name the city. They asked him, have you ever went there in the 4 months? He said, no, I don't go there 4 months. And these universities require 4 to 6 days of classes a year, and that doesn't look like. Yeah, are we opposing the theory that the digital technology has come in, you don't have to go in? No, we're not opposing those things. The thing, what you need to remember is that you are in this country to go to class. If you were to digitally attend without going to college, you can do so in India. You don't have to come here on a student visa. So if you have ever attended these universities, it will be a black mark even if you have not taken the Day 1 CPT. That's my opinion. Because you're not attending the classes. And sometimes what happens is that if the university gets into trouble, they will look into all your things, what universities you have gone in, and you may be in trouble. So I will strongly recommend to avoid the universities if they are giving Day 1 CPTs.
Mohammed from Facebook had an H-1B filed in April of this year that was selected. Now has a request for evidence on the employer-employee relationship, but the end client has changed since the time of filing, and he wants to know what the outcome of the case could be. Unfortunately, that type of situation has a high risk of denial. Because when your company filed the H-1B in April, they said that they had 3 years of work available at that location starting from October 1st, 2019 until September 30th of 2022. Now, the project has ended, you've moved to a new project, way before that was expected. And so they may have difficulties proving that the first project wasn't a speculative type of employment situation. And the other issue is when you're changing the project, if the work location has changed to where a new LCA is required, now there is not possible to get an LCA now and reply back to this pending case with an LCA that was certified after the time of filing. So I think there's a good chance that this could be denied.
Srinivas Gopal has this question. He is converted from OPT, STEM OPT to H-1B in October. What's a good time to file for EB2 or EB3? Right now, immediately, yesterday. There is no requirement that you have to wait a certain amount of time after you get the H-1B. I would do it immediately. Many reasons, Srinivas, is that if your employer has given an opportunity to apply for the labor I-140, I would do it immediately, because once it passes 6 months after the I-140 is approved, that belongs to you now. So you can do a lot of different things with those things. You can have your spouse get an EAD under the current circumstances, and maybe things will change, the legislation will change, priority date may move, you don't know. H-1B can be extended beyond 6 years, that's another thing. Maybe you will move to a different company, maybe they will not file a labor and I-140. You can still use this labor and I-140 to extend the H-1B beyond. My advice to the people is that if you get an opportunity to file a labor and I-140, do it, take the opportunity immediately. Don't go to the 5th year and then struggle at that point of time. Try to do it as early as possible.
Sriman from YouTube wants to know about the possibility of getting a 3-year H-1B extension because he has an approved I-140, but the project documentation right now only shows that it's valid for 6 months. He's working for a third-party placement, has an end client that's willing to give a letter that states that the project might last for 3 years. Will USCIS give an approval for 3 years? We see it go both ways. So just because you have the I-140 approved does not require USCIS to give a 3-year extension. We do see a lot of times where they shorten it based on the project documents. We do have some litigation pending right now on that exact issue on basically arguing that USCIS doesn't have the authority to shorten approval notices. There's nothing in the statute or regulations that says they should be doing that. So that lawsuit is still pending, but unfortunately it really could go either way with that kind of documentation.
Kajol has this question. She is 61 years old and turning 62. Can she apply for the Social Security benefit? She's on H-1B, and then can she go to India and get it into the bank account, US bank account? I'm not going to comment very much about what time you will be eligible for Social Security, but let me tell you one thing. If you are on H-1B and you are applying for Social Security, you need to say that you are not employed. I don't think so. You can be employed and still apply for the Social Security. But if you go to India and you keep maintaining the US bank account, you can still apply for the Social Security even when you are in India. I have recently written an article and published it at RN Law Group. It was actually last week that I published it. For the people who have worked for more than 10 years, even if you're staying in outside the country, there are certain limitations which outside countries are not allowed. There are very limited countries. Iraq used to be one of it, but not anymore. If I do recall, it's Iran and it's and North Korea. These are the two countries that I remember. Definitely India, China, they are good countries. You can go there and still get the Social Security. It requires that you must have contributed for 10 years and you reach a certain age. Now, I'm not going to discuss a certain age, but I've written an article on it at RN Law Group. You can, and there is a link that is provided to the Social Security Administration, then you can check those details out there.
Arun from YouTube wants to know, and this is something that we meant to discuss at the beginning, one of our topics. He wants to know if he can work from India or his home country on H-1B status for more than 6 months. So I think that's a big misconception, is people think that they're in H-1B status when they're outside the U.S. because they have an H-1B approval notice. So when you are physically outside the country, you are not maintaining any U.S. immigration status, and you're not required to. You don't have to have any kind of work authorization from the United States if you are working in your home country and physically sitting there. Go ahead.
So Emily, if I don't have any work permit in USA, and I have never even visited USA, can I sit down in USA and work for US company without any work authorization?
Well, no. Sit down in the US?
No, sorry. Sit down in sit down in India and work for US company.
Yeah, absolutely.
What? So wait. Somebody in India can apply for a remote job, let's say with ABC Inc., and they can sit down in India if they're Indian national, and they can work for ABC Inc. in USA without any work permit.
Correct.
They don't need immigration lawyers like you and me.
No. Nope.
Okay. Yeah, a lot of people are getting confused on it, that when and especially when people's extensions are getting denied, when people's change of employer are getting denied, they don't understand that they can go and work in India. When you go and sit down in India, you are subject to the Indian law. Right now, the governments do not recognize cyberspace as a space at this point of time. So if your butt is sitting in India, you are subject to the Indian law. If your butt is sitting in USA, you are subject to the US law. So if you are sitting in India, sorry for using the bad word, it's not a bad, but if you're sitting in India, you're subject to the Indian law. You're an Indian national, you can work. So you can work through a US company, absolutely no problem. No work permit is required, you are fine. So if any time when your extension gets denied, when your transfer gets denied, you can still go back to India, you can remotely work, absolutely no problem with that. There are some income tax requirements you might have to meet. You can check with the CPAs or chartered accountants. They will guide you on that point. But as far as the immigration lawyers is concerned, we are telling you very clearly, you can work from India to a US company sitting in India without any work permit.
And I think that's a great alternative to these day one CPT schools.
Right.
You know, if your STEM extension is expired and you didn't get selected in the H-1B lottery, there's no need for you to risk your status by doing these day one CPT schools to allow you to work if you can work remotely from any other country. You don't require U.S. immigration or U.S. employment authorization for that. And while you're doing that, your employer can file the H-1B for you in the lottery coming up this year. So there's no problem with being outside the U.S., being sponsored for the H-1 while you're remotely working from outside the U.S.
Tushar has this question. If somebody does an MBA in healthcare management, will they be eligible for the H-1B cap in the master's quota for a business analyst? Yes, the master's degree doesn't have to be related to the H-1B position. So for example, if you get a law degree, which is considered as a master's degree, and then you actually are going to work as an engineer because your basic degree is an engineering degree, and you're going to work as an engineer, absolutely you can. Just because you got the master's degree in a different field and you're going in a different field has nothing to do with the master's quota. You're still eligible to get to the master's quota, even that the master degree is not relevant. And one other thing that I want to address to this is that, Emily, there are a lot of universities that are not accredited. Can they go and file in the master's quota? These are unaccredited universities in the USA.
No, that's really important to know. So your university has to be public and accredited, or not-for-profit and accredited. But either way, it has to be an accredited university in order to qualify you for the master's cap. So if it's not accredited at the time you graduate, you're not considered for the master's cap.
So there is thing. One is accreditation, and for it has to be a non-profit also for master's quota. Now when it comes to the STEM extension though, it just has to be accredited, is right? But when it comes to the master's quota, it has to be not only be accredited, it has also be in the non-profit. Recently, we have had about 4 or 5 notice of intent to revoke. They approved the H-1Bs long before, and now they are revoking because their university is for-profit university. Please check if your university is for-profit or non-profit universities. There is one university, namely Stratford University, not Stanford, Stratford University, that is for-profit university. So we have had issues with the master's degree quota with that university.
Vikram has a question on YouTube, and I want your opinion on this one. We talk a lot about whether certain activities are considered unauthorized employment when you're on H-1B. So his particular question is, can he work at a seasonal farmer's market on the weekend selling home-baked goods? Would that be a violation of H-1 status?
That's definitely a violation of H-1B status. If you are working for a Red Cross society, or you're working some religious organization, and you're selling the food, let's say in a temple, church, or something like that, and you're making the money for the church, that is considered as a charitable work. But if you're going to the farmer's market and you're selling the produce and you're trying to make the money, your intention there is to make the money, that definitely is considered a violation of the H-1B status.
AJ wants to know if the H-1B approval expiration date and the I-94 expiration date can be different. Yes, there's a couple of different situations where that happens. The first is the 10-day grace period that USCIS often adds to the end of an approval notice. So your H-1B petition approval up at the top will have the 3-year period, and the I-94 down at the bottom will add an extra 10 days. That's meant to be a grace period after your status is over for you to wrap things up and leave the country. You also can have different dates if you are entering on a visa that's in a passport that's expiring before your I-94 expired. You'll often get a shortened I-94 at the port of entry due to the passport expiration date.
Navin has this question with regards to his OPT and STEM extension has been expired. He has done a master's degree from an accredited and non-profit university. Is he still eligible for filing under the master's quota? Yes. You don't have to be on a student visa to apply under the master's quota. You could be in India and still apply for the master's quota. You could be in H-4 and still apply under the master's quota. if you have the proper university degree. This interesting question comes in, which requires a little bit more intellectual thinking. Or Prasad from YouTube has this question: what's the difference between an EB-1 self-petition, EB-1 company-sponsored? What are the drawbacks of the company-sponsored EB-1 visa? EB-1, if the company sponsored, and let's say you are not working with that company anymore, you cannot file the adjustment of status. That's the main thing. So let's say, for example, if you're working for a research organization, let's call it as ABC Research Organization, that filed for you to get an EB-1A, and now you're not working for that company, then you have to file an EB-1 again. Getting an EB-1 approval is not easy nowadays. It's not like EB-2 and EB-3. The denial rates are very significantly higher in EB-1. So if you get the company sponsored and you move to a different company, that is going to be a drawback. But if you self-petition on an EB-1A, and though you're working for ABC organization, now you moved into XYZ organization, you could still file the adjustment of status under limited circumstances, assuming that your position and certain other things are very similar. You can still file the adjustment of status when the priority date becomes. So ideally, if I have an option of EB-1A getting approved in both self-petitioning and the company, I would go for the individual petition because it will give you a lot of more flexibility for you.
Tejas from Facebook has been on H-1B since 2018, approved through 2021, and his sister is a U.S. citizen. So he wants to know if it'd be a good option to file for the green card through his sister or through his employer, since there's a lot of wait time for Indian nationals. I think you may want to consider doing both because your sister would file an I-130 petition on your behalf, but that I-130 does not allow you to extend your H-1B status beyond the 6-year limit, and that I-130 has a long wait as well. So in order to be able to continue your H-1B beyond the 6-year limit, you're going to need to have your employer sponsor the labor and I-140, and then you can have your sister sponsor the I-130, and whichever one happens to be current first, go ahead and file the 485 based on that.
The question that comes from Ujjwal is that by November end this year, EB-4 and EB-5 will the surplus of the EB-4 and EB-5 move into EB-1? Well, the year end is actually September end, not December though. When it comes to the immigration, the year starts from October 1st and ends on September 30th, not December 31st. So we have to wait to go into all the way to August or September to see if any of the excess EB-4 and EB-5 will roll into EB-1. There's been a rolling to EB-1 has reduced significantly in the past 4 or 5 years. Previously, we used to have even EB-1 rolling to EB-2 and EB-2. But even that stopped completely right now from EB-1 to EB-2. And there's no rolling over from EB-1 to EB-2. And rolling over from EB-4 and EB-5 to EB-1 has reduced significantly.
I think we have time for one last question. This is from Neha from YouTube. She wants to switch from H-4 to F-1 and wants to know if she needs to go for stamping for that or if she could do the change of status in the U.S. For her specific situation, you can do it either way legally. You can file a change of status from H-4 to F-1 while you stay in the U.S., or you can go for F-1 stamping if you can convince the consular officer of your non-immigrant intent. The difficulty with the change of status is the very long processing time. It's anywhere from 4 to 6 to 8 to 10 months to get that change of status, depending on which service center it ends up at. And in your situation, potential divorce situation where once the divorce is finalized, you'll lose your H-4 status. If you lose your H-4 status before the F-1 is approved, your F-1 change of status will be denied because you have to maintain your H-4 status up to within 30 days of the F-1 change of status start date. And they're going to keep extending the start date of your nursing program because the processing time is so long for the F-1. It's a little bit complicated, but you may need to consider going for stamping and probably should speak to an attorney on that.
Krish has this question. I got a H1, I got a job offer which is different than the previous job. Can I file a different extension even though one extension is pending? Yes to the answer to the question. As long as your previous I-94 has not expired, I would file one more extension immediately rather than wait for the extension to be approved and then file it. If the job has changed, I would file an extension if the I-94 has not expired. If the I-94 has expired, I would recommend to contact a lawyer.
All right, I think we're about out of time for today. Thank you so much for joining us. If we didn't get to your question, please know that we have a daily conference call where you can dial in and get your quick questions answered there. That's for free. You can get the login information by going to rnlawgroup.com and look for the conference call. And you can always set up a consultation with us or any of our other team members who are well experienced in all kinds of H-1B, F-1, L-1, green card, all types of immigration for employment-based categories.
Thank you very much.